The use of autonomous space objects.
Okay, the microphone is high enough now, thank you. I have been introduced, so let's move on. Because the space exploration is very specific, discussion about the needs of having autonomous devices have been present since the cosmic era began. So, since Sputnik 1 of the Soviet Union was placed in the space, we have been talking about it. I want to make reference to what my colleagues said before. The need to talk about autonomous systems occurred in other areas later, but in space-related debates, it was present from the very beginning. Why? Because the space exploration is specific, as I've mentioned, and that's for strictly technical reasons, and it involves also the nature of space. You know, the space involves large distances. There's some delay in communication because of that. In space, there's electromagnetic radiation that sometimes interacts with electromagnetic field used for communication. So on the other hand, in cosmic objects, there can be transmitting and receiving systems that have relatively small power. So space exploration is specific, and the autonomy was considered to varying degree from the very beginning. We may ask a question: is the need for autonomy always present in the context of space objects? And the answer is no. This diagram, I think, shows very well the sphere around which this discussion is relevant at all. It's justified at all. You have three assumptions here. Three circles, or these ovals, represent three assumptions. One, there are changes in the space object. Two, changes in the cosmic objects are impossible to foresee, unforeseeable. And assumption number three, communication time with the space object or assets are limited. And on the verge of those three zones is where we define space in which we may examine autonomy. Beyond those spheres, it's not justified, and it would be, art in itself, development of something without justification. So the development of autonomous systems in the cosmic context is considered a priority, one of priorities. And that's how NASA JPL sees it, which is the laboratory for jet propulsion of NASA. In their technological strategy of 2019, that's how they worded it out. So I say NASA JPL said it, but in terms of autonomous systems, robotic systems, NASA JPL is a leading R&D center in the world. They set out trends in this matter. And we may ask a question: the priority in this respect, is it well justified, or is it just to develop an idea rather than practicalities? Does it respond to practical needs? And this is the answer to this question. It cannot be other that there are real needs. These two diagrams, or graphs, they illustrate the planetary missions. There's a Viking from the 70s, now we have Perseverance on Mars. In the future, we will have Dragonfly fly on Titan. This is related not only to space objects that have the planetary missions. The use of autonomous systems impacts the model of the space mission itself. They become less conservative. I mean, conservative in terms of the goals. They may have more complex goals. They become more flexible. And assuming at the same time that the resources, such as financial assets, are limited. So the development of autonomy brings rather advantages. That is why NASA JPL set out this priority. At this point, let's add that the aspect of advantages with the autonomous character of space missions is related not only to planetary missions, but also the orbits where we place satellites. I'm thinking about the satellite constellations. That's a phenomenon when we put a large number of satellites, not single ones. And here, autonomy may impact not only their location, but also management of their movement. And this is one of very urgent tasks, how to coordinate the traffic in the orbits in a way that would not generate collisions, at least. Here, autonomous systems may play a role. This cloud actually sends us to a very interesting experiment. It took place some time ago. The autonomous spacecraft experiment was conducted over 20 years ago by NASA. Of course, NASA JPL participated strongly in it, and back then they tested autonomous systems to select data that will be obtained by the satellite. Then the data in a selective way, based on autonomous decisions, were processed, and then again, selectively, with the use of autonomy, they were sent to Earth, to the receiver systems. What I wanted to show you as an introduction to our legal aspects, because I would like to go into the legal aspects, this is of key importance. The first legal challenge is the name. The concept needs a proper naming. The name of autonomous space object is not present in international, neither in EU cosmic law. It is absent in the Polish Act on the Space Activity from 2025. Just speaking half seriously, half jokingly, I think we will have an opportunity to do it because the space object has to be able to function on its own. So I don't know what the lawmaker meant. I don't think they meant autonomous space object. So let's try to decode the meaning of this object, since there are legislative gaps, that, as I've mentioned. The term of autonomous space object is comprised of these two elements: space object and the feature which is autonomous. The space object is one of the most important notions in international space law, and although it is of crucial importance, we cannot say that it has been used in the international space law. There is no good definition of it, because space object comprises the parts of space object and the equipment that sets the space object in space. And this is on the basis of the International Convention on the Responsibility for the Damages by Space Objects from 1972 and registration of objects released to the space from 1975. So this notion in itself is far from being perfect, but it has a value. So when we talk about a space object, when we analyze space object, we do not think of the planets that are not space objects. And then definition from the draft of law on the Space Act is more ample. Space object is a mobile item able to function on its own in space, taken into space due to the equipment that brought it there in a planned way and is active or inactive, or it's the device that set it in space, or space object covers the notion of its parts that it's comprised of. It may seem not quite logical, but it's what we have in the Polish draft of the Act of Law. We talked today a lot about AI Act, and then in motive 12, we have autonomy defined as independency from engagement on the part of a human being and ability to take action without human intervention. And there are grades to that autonomy. That's the explanation provided in motive 12. AI Act sees autonomy with certain grades to it. It's like we heard from Popowska-Dąbrowska before. There are several phases of autonomy. The degrees may differ, and AI Act confirms it. Now, taking into account what we know about the space object and autonomy, we may set out a proposition of a definition. It won't be perfect, but it will be, there will be a definition of it. Also, we may assume it's a cosmic object, space object that was designed to function in space with a different level of independence from the human and involvement in its activity and its survival with no human intervention after it's implemented. Not every autonomous space object will meet the requirements of the AI system according to AI Act, but it may be so. What are the prerequisites for the AI? It needs to be a machine system designed to act with a different autonomy level after it's implemented and on the strictly defined purposes and goals with predictions, contents, guidelines, and decisions that may impact the physical and virtual environment. And the last requirement is facultative. The space autonomous object may be used as AI and may be covered by AI Act. It's very important for the countries that register space objects that are EU members or in the European Economic Area. The consequences of having this space object registered in the national system bears the consequences. So this law applies to space object and people who are in this object. So theoretically speaking, the AI Act may apply to this space object. That was the first legal challenge related to the use of autonomous space objects. That was in the matter of terminology, and it's quite basic. The second one pertains to international responsibility or liability for damages made by the autonomous space object. Before I go into the details, let me say an obvious thing. Activity in space is risky. It's often emphasized in articles. It may generate damages. Space object may damage things. It was reflected directly in international agreement of a very long title, but I'm not going to quote. But this agreement is a sort of constitution of how we carry out some activities in space. There are basic rules of how human beings work in space. This Article 7 speaks about very risky activity in space that may incur damage, and it reads, every state of this contract that launches or makes a launch of a space object, including moon and all other celestial bodies, and every state that has a territory from which territory it was launched is responsible for the damages incurred by such object or its part on Earth, in space, and on Moon and places. Article 7 regulates the international responsibility for the damage. You know, this title is very long, so it's really hard to get a grasp of the essence of it. But if there is damage done by a space object as a result of legal activity in space, there's liability. So it does not cover illegal activity. So it's liability and not responsibility. It's very difficult to differentiate it in the Polish language. So we can see in English that the Article 6, that I did not quote before, speaks about responsibility, and Article 7 speaks of liability. Article 7, the one that we analyzed, was expanded in a separate convention from 1972, and that's an important matter. Important things were regulated in detail. Article 7 and its convention that expands it have a compensation function because they cover the compensation of a damage made by space object to some entities that are under the jurisdiction of the state that is indirectly at damage. So it's not the state that incurs the damage, but it's individuals, citizens of that state that had a damage done to them. Now, the International Convention from 1972 regulates the liability based on two principles: the absolute or nearly absolute, in the way that Professor Rajski defined it, and he is the author of a very important monography about it. But that's not what I want to talk about. There is another sort of responsibility or liability based on a different principle, and it's guilt. It's regulated by Article 3. If the damage is done somewhere else than the space of the Earth to a space object of one country, a launching, or people or assets that is incurred on the space object or by the space object of another country that was launching it, then there is responsibility only when the damage was generated out of their guilt or out of the guilt of people who are responsible for it. So that's the differentiation. What's interesting, this event that falls under the provisions of the Article 3 were rare. The first was in 2009. Satellite Cosmos 2251 collided with satellite Iridium 33. That was the first case in the history, but it just the number of these collisions will rise because of the very sharp rise in the number of satellites in the Earth orbits and the idea of the satellite constellations. So the Article 3 of the Convention from 1972 say that there's not only a kinetic collision, it may be an event that is due to an unfavorable impact of one object on another, for instance, interfering with the systems because this one satellite is too close to another. Now, what are the consequences of this guilt principle? It was also in the previous presentation. So if we analyze the topic of guilt with regard to systems that have sole autonomy or very advanced autonomy, if we speak about the AI systems, it's difficult for the entity that has a weight of evidence to prove the causality and the decision makers. So the decisions that were made by the autonomous space object and the owner of it. So the weight of evidence is on the side of the country that wants to be compensated for the damages. So they not only need to prove the guilt of the damage, but also prove the causal relationship between the AI and the owner. And the higher autonomy, the more difficult it is. This topic is not only specific for the space activity. This similar problem is seen in AI activity as such, and it is regulated by a directive that would regulate responsibility for AI. And there is some difficulty in showing the causal relationship between the owner of AI and the AI's decisions. That made the regulator at the EU level design Article 4 that would perhaps have a target solution whose the connection, the causal connection between the guilt of the sued party and the result obtained by the AI system. So this is another issue to be still developed. Next question, towards the end of my presentation, is whether while operating space objects, particularly the ones with high level of autonomy or their AI systems as such, should we ask at all about the guilt? Is guilt principle relevant? Maybe we should rather switch from guilt to risk. Maybe the risk is the only reasonable proposal here. And in the context of the EU directive, this is considered as well. Moving from regulations where there's the guilt as a principle to the risk principle. And this is analyzed by the co-creators of this EU legislation. This question remains relevant, and I guess most relevant, even if we decide that it is, and that's the last thing that I want to say, there will be a problem, and the problem is the space treaties, the so-called space treaties that are in international space law, they're not changeable. They have functioned as such from the very beginning when they were ratified. From the 60s and 70s, they were not updated, they were not changed. Why? Well, not for legal reasons. We know what should be regulated and in what way, but there are political reasons for that. No political willingness is visible in terms of changing space treaties, not only coming from the guilt to risk principle, but there are issues to be regulated that are not regulated, and this is political. Big players, US, China, Russia, Japan, they have functioned in general terms of these treaties, which is beneficial for that because they may interpret them in line with their own lines of profit. Thank you very much. And ladies and gentlemen, I invite you to take part in the discussion moderated by Emilia Folek.